If you believe the American justice system only works when everyone agrees to play by the rules, then what happened today should stop you cold. Because what unfolded inside a federal courtroom in Manhattan wasn't just another legal clash. It was a direct collision between the authority of the court and a defense team that decided in real time that the rules no longer applied to them. This is one of those moments that doesn't feel historic while it's happening, but later people will point back to it and say that's when something snapped, and late this morning while court was actively in session, something extraordinary happened. 3 elite defense attorneys, some of the most expensive legal talent money can buy, stood up from their seats, gathered their documents, and attempted to walk out of a federal courtroom while the judge was still speaking. Not during a recess, not after an adjournment, mid-proceeding. Let that sit for a second. Officers of the court, bound by oath, tried to abandon a live federal trial because they didn't like a ruling that had just come down. What followed is something that almost never happens anymore. And to understand why it matters, you need to know what led up to it. So the morning began quietly. Observers described it as procedural and unremarkable. So the prosecution moved to introduce a large batch of financial records, and the defense objected, motions, counter-motions, the usual rhythm of a high-stakes white-collar case. Nothing that would make headlines on its own, but behind the scenes, pressure had been building for days. 2 days earlier, a sealed filing briefly appeared on the federal court's electronic system. It was visible for less than 20 minutes before being removed, long enough for legal analysts and court watchers to capture it. According to multiple people who reviewed the material, the filing contained newly submitted evidence, encrypted communications between Donald Trump and several co-defendants during a period when the defense had insisted no contact occurred. There were also financial transfers totaling millions of dollars, and a detailed timeline that prosecutors reportedly believe ties the entire case together. This morning, Judge Patricia Caldwell ruled the entire submission admissible. Hundreds of pages, every last one. And that's when the courtroom atmosphere changed. The lead defense attorney rose and accused the court of abandoning neutrality. Another attorney followed, claiming the trial had become illegitimate. Their words weren't aimed at persuading the judge. They were aimed outward, at cameras, at audiences far beyond that room. Then, without waiting for a response, they turned toward the exit. Judge Caldwell is not known for theatrics. She's been on the federal bench for decades. Defense attorneys generally consider her fair, restrained, almost impossible to provoke. But when she saw what was happening, her tone hardened instantly. She warned the attorneys that if they took another step, they would be held in criminal contempt, and she ordered U.S. Marshals to secure the exits. Within seconds, armed federal marshals were positioned at every door. The room froze. For over 7 minutes, no one moved, no one spoke. It was the sound of a system testing its own limits. The attorneys stood there visibly weighing their options before finally returning to their seats. And then the judge explained why this wasn't just about evidence. She revealed that earlier that morning. She had received a sealed ex parte submission from the Department of Justice. That phrase matters. Ex parte means one side only. Judges almost never allow it. When they do, it usually involves witness safety or national security. On the record, Judge Caldwell stated she was considering enhanced security measures and possibly sequestering the jury. Every experienced defense lawyer in America knew what that meant instantly. The government has a cooperating witness, someone close, someone protected. Within minutes of sitting back down, the defense team filed emergency motions claiming bias, misconduct, and demanding a mistrial. They also moved to have the judge removed from the case. It was a legal counterstrike, clearly prepared in advance. And here's where things get even more unsettling. Media crews were already waiting outside the courthouse before any of this became public. Political commentators were posting about judicial overreach before reporters inside the room had finished filing their stories. The timing didn't feel accidental, it felt coordinated. Sources later confirmed that the sealed submission relates to testimony scheduled for next week from an individual referred to only as witness 14. This person has been in protective custody for months. That level of security isn't routine. It's reserved for cases where the risk is real. So legal analysts believe this witness has direct knowledge of the financial operations at the heart of the case, someone who handled money, someone who saw everything. And if that testimony unfolds the way prosecutors expect, the defense is in serious trouble. Judge Caldwell didn't stop there. After the standoff, she warned that she was considering appointing backup counsel lawyers who would sit in the courtroom ready to take over instantly if the defense tried to withdraw again. That move alone sent shockwaves through the legal community. It's rare. It signals a judge who believes the integrity of the process itself is under threat. The financial consequences are already spreading. Reports indicate the defense firm has billed tens of millions of dollars and has entered urgent discussions with its malpractice insurer. If the attempted walkout results in a mistrial or appealable error, the liability could be enormous. Senior partners reportedly convened late-night meetings as the reality set in. And this is where the bigger picture comes into focus. If attorneys can disrupt proceedings by simply walking out, the entire system collapses. Judge Caldwell said as much on the record. Allowing calculated chaos would incentivize every losing party to manufacture a crisis, And once that door opens, trials stop being searches for truth and start becoming political performances. History backs her up in the rare cases where defense teams have tried similar tactics. The attorneys faced sanctions, and the defendants were convicted anyway. The political reaction was immediate and explosive. Trump himself framed the incident as persecution. Some lawmakers echoed that language. Others pushed back hard, emphasizing that no one, not lawyers, not politicians, gets to override the court because they dislike a ruling. Public opinion has been striking. Polling shows a strong majority of Americans, including many Republicans, disapprove of the walkout attempt and agree that the law must apply equally. Even legal commentators normally sympathetic to Trump called the move indefensible. There's one more detail that hasn't gotten enough attention. A member of the defense staff claims the lead attorney received a text minutes before the walkout attempt. 2 words: abort mission. The message allegedly came from a political strategist, not a legal advisor. If true, it raises the possibility that the entire episode was designed for optics, not law. Judge Caldwell appears to suspect the same. In a written order, she warned that future attempts to turn the courtroom into a political stage would result in severe penalties, including arrests and professional referrals. Security has since been ramped up dramatically. Additional screening, increased law enforcement presence, intelligence monitoring. This is not normal. It reflects how volatile the situation has become. International observers have taken notice as well. Foreign media outlets describe the incident as a breakdown in courtroom discipline. Adversarial governments are already using it as propaganda, pointing to it as evidence of institutional weakness. Behind the scenes, there's now talk of replacing the entire defense team with even more aggressive lawyers, and that would put the judge in an impossible position, allow a delay and risk manipulation, or force unwilling counsel to continue and invite appeals. It's a trap carefully engineered. Meanwhile, prosecutors are reportedly considering extreme options of their own, including challenging Trump's release conditions based on courtroom conduct. And even if unsuccessful, the message would be clear. This is no longer just a trial. It's a battle over whether the justice system can still enforce order. And don't underestimate the jury. They feel tension. They notice defiance. Jury experts say behavior like this often backfires, signaling desperation rather than strength. On Monday, the judge will rule on the mistrial request. She'll decide whether witness 14 testifies as scheduled. Marshals have reportedly been briefed on arrest procedures for attorneys, something that hasn't happened in living memory. So zoom out for a moment. With an election approaching every day, this trial continues matters. Some believe the chaos is designed to delay, to derail, to push consequences past the ballot box. Judge Caldwell seems determined not to allow that. What we witnessed today wasn't just legal brinkmanship. It was an attempt to convert a federal courtroom into a political arena. And if that succeeds, the implications extend far beyond this case. Because when money and power can bend procedure, when trials become performances, when lawyers flee instead of argue, and the rule of law starts to look optional, that's the real question hanging over all of this. Not whether one defendant wins or loses, but whether the system itself can hold. Make sure you're subscribed. Turn on notifications. When witness 14 takes the stand, when the judge rules, when the truth about that message comes out, you'll want to know immediately. This isn't just another headline. It's a test of whether we still believe in practice that no one is above the law.